Hello, my name is Andrew Nyamayaro. I am a solicitor at Tanlo Solicitors, and of late, since when the Secretary of the Home Department made an announcement on the settlement proposals and consultations, I have been receiving a number of calls, a number of WhatsApp messages, and a lot of people are concerned, and they want me to give an explanation, or at least give a view on what is happening at the moment. So I'm going to comment on the immigration updates. So the position is that sometime this year in May, the Secretary of State introduced a white paper, and the white paper had an agenda of changing the immigration laws in the UK. So it proposed a number of things within the white paper, and the things that were touched in the white paper included changes to the skilled worker, particularly and especially on the healthcare visas, changes to students, COS updates, sponsor duties, and settlement, and issues to affect children and asylums and so forth. So, what has been happening at the moment is that since May 2025, the Secretary of the Home Department has been implementing the changes that were introduced in this white paper, and it has been a phased approach that they've been doing. So the changes didn't start yesterday or a few days ago, as many people are concerned. They started in May 2025. And I am taking this opportunity to explain what changes have been done so far, and the changes that will be done, the consultations that are taking place, and give you my own professional view on it. And as I have said in the disclaimer, please treat this as general information. Seek legal advice from people that are competent, whether they are lawyers or any other advisors that can help you in your case. So the white paper objectives were to reduce net migration, and it was also to reduce less skilled workers, because before the health and social care visa was introduced, most of the jobs were on a highly skilled level, degree level, but it was reduced to allow people to come with lower academic qualifications to do the jobs that were in high demand, but with anyone doing the jobs. So effectively, it's to reduce the migration or net migration to the UK. And the key elements of that is that the white paper introduced a higher level of English, or is proposed to introduce a higher level of English. The minimum qualifications have also been introduced, have also been increased from RQF level 3, which, for example, most of the people in health and social care under the care visa R, which is hierarchy of level 3. It also deals with trusted universities, and it has also enhanced or made the sponsor responsibilities for companies that has got sponsor licenses more stricter and requiring more information and making the process um, more durable according to the Home Office. But even though it's causing a lot of issues to the employers, the issue that was being dealt with the document, which the Secretary of State has termed Fairer Pathway to Settlement, which was introduced in Parliament by the Secretary, um, is to do with settlement and how settlement going forth, if the consultations have been concluded, is going to be. So I will also be commenting on those issues to do with settlement as well. So, for the health and social care visa, most people believe or think that the sponsor license started recently. The sponsor license has been there for a long time in different names. Previously, it was maybe called the work permit and so forth. So many different names that it had before. But the sponsor license became popular due to the health and social care visa that was introduced in the time when Boris was in power, having identified that there was a shortage of carers and workers in the social and care sector. So most companies applied for their sponsor licenses and they were able to recruit a number of people from outside the country or even within the country, because when it comes to the sponsor license, the certificate of sponsorships, as you would know, we have got the defined sponsorship and the undefined sponsorship, the certificate of sponsorship. So the health and social care, particularly the care visa, has been going now for almost 5 years now. But the government have decided to close that route. Initially, well, it will be closed and phased out in 2028 July, so it's still there. But what has been stopped now is that you cannot recruit anyone from abroad under the under the carer or senior carer visa. You cannot recruit from abroad anymore. Anyone that is within the UK can still be either given an extension, can move from one employer to the other, can be promoted, and or can swap the SOC codes. It's still permissible for those people. But something that people have to be careful about at the moment as well is that if you are coming from another standard occupation code to the carer visa, then you need to be careful whether or not you will still be covered by the transitional arrangements, so that you'll be able to either bring your dependents, or if your salary is not going to be affected, or you're going to put yourself on a SOC that will require you to pay in the insurance health surcharge. So the major changes that has happened so far in the care and care senior carer and carer visa is that you cannot bring any dependents, and also that the English requirement in the future might also, like another part of the visas, might also be increased and so forth. In terms of the salary, the good thing about the health and social care visa is that in terms of the salary, it still remains on 25,000. While again, there's been a change in the salaries, which are now over 41,700 for most jobs, unless if the going rate is at another level. And for PhD people, it's 33,400 to 37,500. And also on big jobs that are on the shortage list, you've got different uh, salary thresholds as well. It is important to note that when you are looking for work, or if you are on a route of a job that you have to check whether it's on the transitional arrangements, the immigration salary list, or on the job shortage list that was also introduced by the government, so that you can see whether or not you meet the requirements of these type of visas that you might be applying for or under. So the other change that was introduced this year is to do with um, the qualifications, as I have said. The care visas are on a lower level, and the government has said that they are going to stop the care visas because they are, and it's not only the care visas, to be fair, there's a number of other jobs that were under the RQF level 6, but they are now at well, they're now going to be pegged at RQF level 6. So any job that was below that, that was being sponsored, and I understand it's a number of jobs that were there, they've now since been stopped. So you need to check the level of qualification that will be required for a job that you will be applying for, or you think that you're eligible for. And the English level is also going to be increased as well and made mandatory, not only for the sponsored employees themselves, but also for their adult dependents. There is that consultation or a proposal that is there that the English has to be increased. That's part of the integration that the Secretary of State is talking about, that you need to be integrated. So English is going to be increased, and those people that were dependents are not required to do English test, unfortunately, will also be required to do the English test. So in terms of the salaries, they have put in there the health and social care. It's on there, which covers the carers, nurses, senior carers, and stuff, and then the standard one for everyone else. When it comes to recruiting students, or if you're a student, you need to be very careful now because the Home Office has outlined certain requirements or clarifications that they've put in. If you are going to recruit someone as a sponsor, you need to make sure that you have checked the university that they're coming from. Is it a highly trusted university? The information is available online. If you get someone who's not from a trusted university, you might risk the Home Office refusing the visa, and maybe also risk having um, an audit done on your company or an inspection done on your company. So you need to check the university, check if they finished their degree. If they are still studying, they can only do 20 hours. Some students can do 20 hours, some can't do any hours at all, some can do 10 hours. It's not always automatic that students will have to do 20 hours. So you need to check again and be sure what sort of work the student can do. Um, and for students, if someone is going to come as a student to study in the UK, unless if they're at PhD level, they can no longer bring dependents as well. So only people that can are doing PhD can bring their dependents, and all the dependents, as I have said as well, are now required to meet the English test, and also the Home Office will be looking at their good character, and there is also stringent residence requirements that are now put in place. If you are a sponsor, um, the white paper have introduced additional responsibilities for yourself. So if you are recruiting carers and senior carers, obviously you need to be regulated by the CQC. But there are some organizations that are not regulated by the CQC, who are maybe, for example, regulated by the Ofsted, but yet employees that they'd recruited before the law changed on a carer or a senior carer standard occupation code. So those ones are covered by the transitional arrangements. They can continue to work. So if you're making an application for your COS or COS allocation or COS edition ones, you need to be clear in your application that these people were recruited before and they're covered by the transitional arrangements. Otherwise, you might risk the application for the COS to be refused, and well, refusals from the Home Office might also mean an indirect or remote audit on your business with it, because normally they'll ask you to send a lot of documents and information when you've made these applications, and those informations can also be used to audit your business. So when you are applying for the certificate of sponsorships, they now require additional information as well, naturally, when you're applying for it. So they will, for example, want to know if the job is available, how many hours are available, how much you are going to pay, the details of the proposed employees, if you've got their names, their date of birth, their emails, their phone numbers, their current certificate of sponsorship number, and so forth. If you give that information to the Home Office, that will help you to get the COS as well. Even when you are assigning the COS as well, and such additional information is required, and you have to put it either when doing the COS or when you are doing a sponsor note in the system. So there is also additional requirements for you on reporting if you are a sponsor, and you have to note that there's been salary changes that have come in place, and if there's anything that needs to be reported, you have to make sure, is it something that is reported within the 10 working days or the 20 working days. It is important to note that there's current delays in the Home Office at the moment. There's when you apply for COS, they are taking up to 18 weeks, sometimes longer. Sometimes even if you are sending the email to do the priority application, they are not picking on the emails and so forth. So that is putting in limbo the employers and the employees. Sometimes employees get to a time of their visa or their COS expiring close to, without a new COS being issued. So under those circumstances, you will need to seek legal advice on what to do to proceed, because you need to submit your application in time before your visa expires, particularly before the COS expires as well. That's quite important. And the employees, like I said, some of them who are under offset companies are covered by transitional arrangements that are there. And the transitional arrangements also cover the dependents, who dependents of people that came to the UK before March 2024, when people were still allowed to bring their dependents. I want to comment on this update on children and dependents, because we are getting a lot of questions in relation to this as well. So on settlement, previously, children and dependents, particularly adult dependents, would automatically just qualify for settlement, do your 5 years, then do your English test, so in your life in the UK, and then you qualify. Sometimes you could even qualify before the sponsored employee is qualified for settlement. This is going to change as well. There's going to be stringent English test required, and they're going to check on your residence as well, and they're going to check on your conduct, so your good character. The Home Office Secretary have indicated that they'll be looking at your criminal or non-criminal history, your um, debt, CCJs, and so forth. These things were being looked at before, but now they are being scrutinized at a higher level, and the guidance of suitability came out about a week or two ago, and there were some thresholds that were in there, whereby, if for example, if you had a fine or a caution, you would need about 3 years to clean up yourself, get rehabilitated, and so forth. But some of those thresholds are no longer there, and it's unfortunate that some people that have got criminal history or have got debts may not get settlement at all, or may get it after a very long time, and may not even become citizens of the United Kingdom. So English is now required B1 for indefinite leave to remain. And if you do English at a higher level, the C1, which is degree level, as I will comment later, that might help you on your pathway to become settled as well. So another point that I want to comment on is in relation to um, adult children. Some children came or when they were around 17, 16, now they are over 18 years, and they are still technically dependent on their parents. But however, what is happening is that because they are young adults, sometimes they do move out of the house, and sometimes they've gone to university, and sometimes they no, do live in jobs and so forth. So you need to show that there is still that element of dependence by the children on you, even though they're adult children. So are they still using the same address with you? Are they staying with you? Are they in a if it's a girl, do they have children now and so forth, so that they can continue being dependent on the parents until they finish the pathway on which they are as dependents of their parents. Okay, so I need to check on something once again. So what has been implemented so far under the white paper? So the white paper was published in May 2025. In July 2025, they introduced the minimum requirement for qualifications and new salary thresholds. And they also closed they defined a certificate of sponsorship for care jobs, and people that are already in the UK only be recruited. And this is going to end in July 2028. Again, you need to exercise some strategy there on how you are going to implement this, and so that you can get another 5 years in 2028 for yourself if you're an employee, or if you are an employer for 5 years from 2028, that will cover you up to 2033 for your staff. And then December, there is going to be a change in the skills charge, which is charged to the employers. So it's going to increase by 32%. In January, the English is going to become enforceable at B2 as a minimum. And at the moment, as we speak, there is also consultations that are being done for the settlement. And I encourage everyone who is listening to me or anyone who is watching me that you need really to um, you need really to engage with this consultation that is taking place. I know that sometimes people don't really follow it up, people don't do it for whatever reasons, but you have your say in what is happening, and maybe you might be heard, may not be heard, but you've taken a chance to do it. And also, try to influence your neighbors, your society, your community, because then they might, especially your MPs as well, engage with them so that you can lobby them so that the settlement period will not be increased. Talking of settlement, this is what has made a lot of people worry, and this has made a lot of people panic. Previously or currently, because we're still doing consultations, someone can get their settlement at 5 years residence in the UK. And I encourage anyone who is qualified for settlement to do it ASAP. And I encourage anyone who is qualified for citizenship to do it ASAP as soon as possible, because things are moving fast and things are changing. So the proposal of the Home Office is that the new baseline of settlement would be 10 years. But there will be factors that will either reduce the 10 years or increase the 10 years. Things to do with your integration, to do with your earnings, and to do with your good character, so to say. So the baseline would be 10 years, and most of the family roots will remain on the 5 years. But some are going, the private life has always been on 10 years anyway. So what is it influences the changes? If you are a high earner and you're earning 125,000 and above, you can get your indefinite leave to remain at 3 years. And if you are working in the public sector, say the NHS, teachers, social workers, and so forth, you can get your indefinite leave to remain at 5 years because you are within the public sector. And if you are earning a salary of around 50,000 or so, you can get your indefinite, I believe, at 7 years. You knock off 3 years. Um, if you show that you have integrated into the community, then you've got good English, you can now reduce by 1 year. And if you are doing integration, say by voluntary work and things like that, that can also help you to reduce your baseline years from 10 years to 5 years. That's why it is now important maybe to consider doing some voluntary work to do things that show that you're integrating into the community and so forth. So where a number of factors apply to you, the Home Office will consider the one which will give you more period or more time in terms of the reduction. So if, for example, you're in the public sector and 5 years is the highest you can get, you can just get 5 years. But if you have got good English at C1, you won't get 6 years, for example, you just get the 5 years. Then there are factors that affect your baseline by increasing it. So if you've got a criminal record, if you came to the UK illegally, if your English is poor, then you and if you're on a low salary threshold. Unfortunately, because of the low salary threshold and also because of the lower RQF level of the care and senior care visas, the Secretary of State has proposed that it will take 15 years for carers to get their indefinite leave to remain. That's why I'm saying it's important for everyone to engage with the authorities so that we can lobby for fairness. Surely it's not fair for someone who came on a promise of 5 years settlement in the UK to then get it at 15 years. That's not fair. That's not right. And we need to lobby the government on that. So the factors is the table that I'm showing you. It's got the minus and the plus factors why the base threshold can change. You need to seek legal advice on this once it is implemented. But as of now, I think the important thing is to engage with the consultation that is taking place. I've already commented about the students. So, what are the practical things that we need to consider? If you are ready for, you already qualifying for the settlement or citizenship, apply as soon as possible. Upskill yourself by trying to achieve the C1 English, and if you can, to study to get to degree level. Avoid things that will cause you problems. One of the things that has been commented in the paper is that if you have used public funds, say for up to 12 months, then they can affect you, I think, by about 3 years. If you use it for more than that, then it can affect you by more than 6 years. So if you are going to have you abuse public funds, you might end up getting settlement after a longer period, more than the 10 years that has been suggested by the government. And if you are in debt as well, that might increase the number of years. But it's not yet clear what do they mean by debt. Because a mortgage is a debt, getting a car on finance is a debt. I think there's good debt and debt bad. Maybe they are referring to a debt bad, but we are yet to see the details of these things. And you need to be contributing to your community and society to reduce the period and so forth. For sponsors, you need to focus on domestic recruitment. Some other SOC codes can still recruit from abroad. The ones which you cannot recruit from abroad is 6135 and 6136. Any other SOC codes you can still recruit from abroad if you can justify it why you want to recruit from abroad. Ensure you comply with your reporting and updating duties, and you are maintaining the hours for your employees, you're paying them, and you're complying with the recruitment, you're complying with um, everything else that needs to be complied with, so that when the Home Office audits you, then you will not be found wanting and your sponsor license might not be revoked. If you've got any questions, any specific questions, you can put in the chat, and then I can be able to respond to your questions. So if you want specific advice, you can contact us. I'm Andrew Nyamayaro from Tanlo Solicitors. On the screen is our contact details, and you can either phone us, email us, and contact us in whichever way is better for you. So I do not see any questions in either the chats, and thank you so much for joining us. If you've got anything bespoke, you can get in touch privately if you wish to do so. Thank you.